1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Audio check. 1, 2, 3, 4.
alarm does go off, it's a real one, so just leave the building, right? Basically the stairs are behind you, beside the lifts as you come up, so we don't expect to have one, but just in case. The second thing is the chairman will come out now, he's going to make some introductory remarks, they'll last about 30 minutes. The remarks will be printed off, so we'll have a copy of those as well, in case you're wondering about scribbling down stuff in the middle of this, there will be a full copy of the remarks at the end, okay? Thank you all for coming this morning. As you know, the patients are upstairs watching this on a live thing down here this morning. Thank you again, and hand you over to the chairman and Professor Massey.
Well, good morning, ladies and gentlemen. Thank you for coming to the launch of the Independent Neurology Inquiry Report. My name is Brett Lockhart, Chairman of the Inquiry, and I'm joined by my co-panellist, Professor Hugo Massey-Taylor. Our first task this morning was to deliver the report to patients who had given oral evidence to the inquiry. And Professor Massey-Taylor and I met earlier with patients and have ensured that they had advance access to the report. Much ink has been spilled on the role of the inquiry. It was not established to determine the clinical issues arising out of Dr. Watt's practice. It was not required to analyse and assess the results of the various recall processes. Its focus has been on the governance of the Belfast Trust and other organisations with responsibility for healthcare. Nevertheless, this report is fundamentally about the safety of patients, and in this regard, there are questions which require to be answered. Were patients let down? The inquiry panel believes that they were. Were opportunities missed over a period of years to identify a problem with Dr. Watt's practice? Again, the answer is yes. And this report outlines in great detail those opportunities. Would earlier intervention have made a difference? The inquiry panel believes that it would have done so, that it would have done. Essentially, the inquiry has addressed three major issues under its terms of reference. First, we examined whether the Belfast Trust should have been alerted prior to November 2016 to the issues surrounding Dr. Michael Watt's practice. The inquiry panel has concluded that the Belfast Trust could and should have intervened earlier, but failed to do so over many years. Secondly, the inquiry was required to evaluate the actions of the Belfast Trust when a GP raised a concern with the Medical Director's Office in November 2016. The inquiry panel has concluded that the Belfast Trust got key decisions right in this period, although it is critical of the communication with patients at this time, and can understand why, for many patients, taking action many years after problems have arisen is of limited consolation. The third issue, equally important, is what recommendations we should make to avoid the chance of a patient recall of such magnitude happening again. In relation to the first major issue, the inquiry has found that the systems and processes in place to assure the public in respect of patient safety prior to November 2016 failed. The extent of problems with Dr. Watt's practice only began to come to light following a concern being raised with the Belfast Trust by a GP. While one process or system failure may not be critical, the synergistic effect of numerous failures ensured that a problem with an individual doctor's practice was missed. And as the inquiry finds, opportunities to intervene, particularly in 2006 to 2007, 2012 to 2013, and earlier in 2016, were lost. It was not just that they were lost, but that the dots were not joined. A concern being raised, for instance, in 2012-2013 was not referenced back to earlier concerns because the view had been taken at that previous time that action was not needed. And in this way, it became impossible to discern a pattern. The failures identified by the inquiry panel are not confined to the Belfast Trust. The panel has concluded that the combined effect of an inadequate investigation into a highly relevant clinical complaint in 2012 by the regulator, the General Medical Council, the failure to disclose significant complaints to Dr. Watt's responsible officer in the Belfast Trust by the Ulster Independent Clinic, where Dr. Watt had a substantial private practice, alongside failures of other health and social care trusts to identify or communicate concerns, compounded a pre-existing problem in the Belfast Trust. Generally, the inability of the systems then in place to identify a pattern of concern was a conspicuous problem. Information was essentially retained in silos. Communication between different organisations and between management levels within organisation was poor and inadequate. After November 2016, the partial restriction of Dr. Watt in December 2016, followed by the commissioning of a report into his practice by the Royal College of Physicians, the full restriction on his practice in July 2017, and the decision to initiate a patient recall in May 2018 were appropriate and served to protect patients. But patients will again rightly point to the many years when problems that emerged with Dr. Watt were not addressed, opportunities were missed, and such inaction was to their significant detriment. The recent response to the global pandemic by the Health Service and the esteem in which the caring professions are rightly held by the general public illustrate just how critical they are to our society. Health professionals deserve to be treated fairly. But at the same time, it was universally acknowledged by all witnesses to the inquiry that patient safety should be the paramount concern and the standard by which governance and systems are addressed. In May 2018, the Belfast Trust announced the largest ever patient recall in Northern Ireland on receipt of a report by the Royal College of Physicians, following a review of the neurology practice of Dr. Watt. On the 10th of May 2018, an independent neurology inquiry was announced by the Permanent Secretary of the Department of Health, Richard Pengilly. As was then no assembly, the inquiry was initially non-statutory. On 11th of December 2020, the Minister for Health, Robin Swan MLA, converted the independent neurology inquiry from a non-statutory inquiry to a statutory inquiry. Now, one of the obvious concerns for any chairman is to ensure that an inquiry is properly independent. We were promised from the outset that this would be the case and that we would receive full cooperation, in particular from the Belfast Trust. I can assure the public today that over the last 4 years, we did have complete independence. And in fact, the Minister's decision in December 20 to convert the inquiry to a statutory inquiry was a measure of the Department's willingness to ensure that we had access to all relevant material. In fact, prior to that conversion, litigation had commenced in the High Court seeking the disclosure of a report into Dr. Watt prepared under the auspices of the relevant professional standards procedure. The decision by the Minister ended that litigation and ensured that the report was immediately available to the inquiry. I can also state today that I am satisfied that we did receive the cooperation of the Belfast Trust in providing relevant documentation. The discovery of documents is a continuous and ongoing process and obligation throughout the duration of any inquiry. And even when documents were found to be relevant, years after the commencement of the inquiry, those documents were made available. This included, for instance, some 30,000 emails which had been obtained from the computer systems of the Belfast Trust in the spring of 2021. The inquiry panel promised in both public statements and in an appearance before the Assembly Health Committee that every effort would be made to publish its report as quickly as possible, not least because patients deserved to have answers about what had happened, why it had happened, and how it could be prevented from happening again. The volume of evidence was considerable by any standard, and the process where those criticised had the opportunity to comment was lengthy. But we believe that we have kept the promise made. It would have been possible to await developments in the Northern Ireland Assembly before publishing the report, perhaps in the autumn. But from the very outset, the imperative has been to get this to the public, and in particular the patients, as soon as reasonably possible. We genuinely believe that if our recommendations are implemented, they will enhance patient safety, and the sooner that can happen, the better for patients. The initial approach of the inquiry, when it was non-statutory because of the absence of an assembly, allowed for a greater flexibility with witnesses and a broader discussion at an early stage on what steps could be taken prior to the publication of this report. Professor Massey Taylor recognised from his earlier experience in Mid-Staffordshire and elsewhere around the world that opportunities are often lost because of a long delay between the emergence of a problem and the publication of an inquiry report. And I will shortly outline some of the initiatives that occurred as a direct result of those early interactions with the Belfast Trust, and in particular its then medical director and present chief executive. When the Health Minister converted the inquiry to a statutory inquiry in December 2020, the inquiry had already heard from 205 witnesses. There was some public comment at the time that the inquiry should begin a process of retaking sworn evidence from all of those who had given evidence to that point. I concluded that the impact on those who had given their evidence to date, the delay caused to the inquiry's work, and the additional work that a retrospective taking of evidence would entail would be disproportionate. We therefore retained the existing methodology with the remaining witnesses, albeit strengthened by the greater powers permitted in a statutory inquiry. In summary, I would not be standing here today, and perhaps not for a further 1 to 2 years, if we had decided to start again. It was envisaged at the outset of the establishment of this inquiry that the Belfast Trust, in its role as employer, and the General Medical Council, in its role as regular, would consider the clinical aspects of Dr. Watt's practice. The voluntary erasure application by Dr. Watt, which was accepted by the Fitness to Practice Tribunal, is currently a matter before the Northern Ireland High Court. But I have publicly expressed my disquiet that patients have not had the opportunity for a public hearing on these issues. Nevertheless, while this inquiry has sometimes had to shoulder increased expectations as to its role, the fact that the regulatory proceedings relating to Dr. Watt did not proceed has not prevented the inquiry panel from fulfilling its terms of reference. What the inquiry found prior to November 2016 was a catalogue of missed opportunities, systems that did not work effectively, and a culture which discouraged the escalation of concerns. The terms of reference asked the inquiry to determine whether there were, quote, related concerns or circumstances which should have alerted the Belfast Trust to have initiated an earlier and more thorough investigation into the practice of Dr. Watt. The inquiry report has answered that question emphatically and found that there were numerous concerns, complaints and circumstances which, if they had been properly evaluated, would have uncovered a significant problem at a much earlier stage. This report is about the safety of patients in the past and about the safety of patients in the future. The systems within the Trust that the inquiry considered were full of relevant information. But when questions are not asked, patient safety is compromised. When concerns are not escalated, patient safety is undermined. When information is kept in silos, the opportunity to identify aberrant patterns of practice is lost. The recommendations are drafted to address these deficiencies. The inquiry report sets out in detail 12 specific occasions when concerns about Dr. Watt's practice were raised at various levels by GPs, registrars, other consultants outside the Belfast Trust and a nurse, but that for various reasons, it was only on the last occasion in November 2016 that the medical director was informed and action was taken. This of itself calls into question the extant medical culture around the escalation of concerns, and the inquiry report considers this in some depth. The inquiry panel was also specifically requested to look at the processes to maintain standards of professional practice. There is a detailed analysis of the current system of appraisal and revalidation, particularly in light of the fact that Dr. Watt delayed sometimes over a period of years, completing his appraisal in breach of his contractual obligation to his employer. This was not the only example of where a trust often failed to utilise the contractual tools at its disposal. The focus was on satisfying the requirements of the regulator rather than enforcing a doctor's contractual obligations with the trust. Further, there was often a perception that as Dr. Watt's clinical competence was not then in question, and that his problems were largely administrative, this should have been less of a concern. The panel agrees with one witness who reflected that a more integrated model of management should view a repeated failure to comply with obligations such as appraisal as potentially indicative of a broader problem in other areas of a clinician's practice. Evidence from the Public Health Agency and others also highlighted a potential problem with Dr. Watt's prescribing of drugs for multiple sclerosis and the use of human immunoglobulin. The inquiry panel considered the manner in which the Belfast Trust and other agencies failed to adequately address the fact that Dr. Watt was such an obvious outlier in this area of practice. Further, Dr. Watt was, by some measure, the subject of many more complaints than other neurologists. The panel has found that there was no consistent method of dealing with clinical complaints, and the emphasis remained on timely resolution in line with departmental guidance. In numerous instances, there was a failure to identify and address the clinical questions sometimes raised in a complaint, seek an independent view, or identify any pattern that arose, even though properly analysed. Many complaints highlighted a potentially aberrant practice on the part of Dr. Watt. Instead of recognising that a well-run complaint system can be perhaps the most effective way of identifying aberrancy, the opportunity for learning from complaints often seemed to have been missed. There was also a focus on the team working arrangements within inpatient neurology services. Why was it that from 2012, Dr. Watt was in a team of one, when the two other inpatient neurology teams had 5 consultants? How was peer review of a consultant's neurology practice meant to work in such circumstances? While an executive summary, which hopefully you'll have received already, has attempted to crystallise the essence of the report, the inquiry panel stresses that there is really no substitute for reading the whole report to understand the issues that have arisen. There are, however, a number of essential points I want to highlight. There was a failure by the Belfast Trust to identify and evaluate whether the exponential annual increase in blood patching procedures between 2013 and 2016 was justified by the plaintiff's condition, or whether in fact it was a threat to their safety. Subsequently, after concerns had been raised, the Royal College of Physicians report and the findings of Dr. Thomas Poicart, who had been asked to oversee the diagnosis by Dr. Watt of a condition known as spontaneous intracranial hypotension, answered this question decisively. Both the college and Dr. Poicart found that in the vast majority of instances, blood patch procedures were not appropriate. There was a failure of the trust management and the broader healthcare system to recognise that problems were occurring with Dr. Watt's practice, which required further investigation. On occasion, it was suggested to the inquiry panel that management is responsible only for that which it is told about. The view of the inquiry panel is that while this may be a mitigating factor, management is responsible for what is actually happening, irrespective of actual knowledge. There was a failure of the health professions, and in particular the medical profession, to appreciate that aberrant practice was happening in plain sight. The inquiry panel noted with alarm that throughout the present system, it is often the case that the perceived requirements of confidentiality come into conflict with patient safety. This was apparent when the panel looked at the provisions of the disciplinary process known as maintaining high professional standards. It was further evidenced by the failure to require the prompt disclosure of patient notes to allow for independent evaluation of a specific case or the disclosure of reports evaluating a consultant's practice. And the conflict was too often resolved in favour of protecting the rights of the individual clinician or overemphasising the confidentiality of patient notes and records when there was an urgent need for their perusal. And this appears sometimes to have arisen because of a misunderstanding of data protection obligations by healthcare organisations. The inquiry panel obtained its own independent legal opinion on the conflict between confidentiality and data protection and the retention of complaints information. And it is satisfied that the current law should be interpreted as ensuring the preeminence of patient safety. Although many of the trust procedures and systems highlight the critical importance of patient safety, confidentiality retains a disproportionate influence in day-to-day decision-making. Healthcare organisations should have confidence that they have the legal authority to obtain and retain information relating to the practice of a doctor, and that patient safety necessitates this. Alongside concerns about the over-influence of confidentiality, the inquiry panel also observed in the evidence perused that what might one term the threshold of proof adopted by the medical profession for raising a concern was too analogous to the criminal standard of proof. Often doctors felt they had no need to escalate a concern because they were not personally satisfied that a problem existed. This contrasted with the approach taken to their own patients, where it was clear that neurologists went to quite extraordinary lengths to confront difficult problems and at the same time cope with a truly onerous workload. If it is the case that escalation of a potential concern about a colleague requires a doctor to be fully sighted on all aspects of a problem before taking action, then the reality is that the action will rarely, if ever, be taken. And the effect of both an undue apprehension about maintaining confidentiality, combined with an inappropriate threshold of proof being required by doctors before raising a concern, contributed to a culture where concerns were rarely escalated. Now, while the terms of reference concentrate on the Belfast Trust, it was apparent from an early stage that the identification of problems was all the more difficult because of the failure of other healthcare organisations to provide highly relevant information regarding Dr. Watt to the responsible officer, who almost invariably was the medical director of the Belfast Trust. This was conspicuous in relation to the Ulster Independent Clinic and other health trusts in Northern Ireland. It is also the case that the General Medical Council, as regulator, failed to adequately assess a complaint which would have greatly assisted the recognition of a distinct pattern of medical practice. It should therefore be borne in mind that the problem of ensuring that the right person has the right information at the right time is a concern which is highly relevant to the entire healthcare system in Northern Ireland. It's not confined to the Belfast Trust. I indicated at the outset today that a result of early engagement with the inquiry, the Belfast Trust commenced work on various initiatives with a view to addressing problems that had already been identified. This includes the introduction of a clinical record review for the future management of all clinical complaints, a weekly live governance meeting to allow for an immediate sense check of safety issues, an additional peer review under a strategy known as building effective teams to protect against the risk of lone working. The inquiry panel is not in a position to evaluate or test the efficacy of these initiatives, but they are welcome, and the recommendations propose that they should be assessed by the Department of Health and, if appropriate, replicated in other health trusts. Now, based on the evidence received, the inquiry has made 76 recommendations to the Department of Health, the GMC, the Belfast Trust, other trusts, the independent sector, and all healthcare organisations who have a responsibility to ensure patient safety. It is the fervent hope of this inquiry that each of those bodies will recognise the urgency of this situation and review current practice with the aim of enhancing patient safety. The focus of each recommendation is to improve patient safety. The inquiry strongly urges all those with the relevant responsibility to engage collaboratively and enact these recommendations which reflect the primacy of patient safety over other considerations. The inquiry has made technical recommendations, but the key recommendations are about how concerns of doctors and other health professionals are heard, investigated, recorded, and appropriate action taken, how complaints from patients are investigated, recorded, and evaluated, as well as responded to appropriately, how appraisal systems for doctors need to be modified, how patients' information is shared across the system, how wherever possible lone working is avoided and a clinician's practice is regularly critiqued by their peers, how the disciplinary procedures for doctors need to be significantly modified, how managers, both clinical and general, need to be better trained, how trust boards need to give equal prominence and weight in the constitution of their subcommittees to patient safety in the same manner, for instance, as they do to the audit committee, how commissioners of services need to focus on their responsibility for patient safety, particularly with regard to waiting list initiatives, how information about a clinician's practice must be recorded, kept accessible, and passed on when indicated, how information about any restriction to a doctor's practice must be shared, how healthcare providers, both NHS and independent, should link with the GMC and the GMC with them, how investigations should be robustly conducted, how clinical guidelines must be followed, how systems for the introduction of new procedures and new treatments must be improved. There are recommendations for the GMC about how it conducts its key role, and also recommendations for the independent sector, which must play a full part in ensuring patient safety, rather than merely being a provider of facilities. Patients rightly expect a private healthcare facility to have similar standards of governance to a public hospital. This is the first of several public inquiries that have arisen more recently in Northern Ireland's health and social care system. It follows a line of previous reports, including Bengoa, Donaldson, and the hyponatremia inquiry. Accountability is rightly sought by the public, and especially patients who have suffered harm. Indignation at failings is a justifiable response, but what is urgently required is reform, change, and implementation. Ultimately, the right information needs to get to the right person who has the knowledge to deal with it and the courage to act at the right time. A key theme of the recommendations is ensuring the disclosure and investigation of information for the enhancement of patient safety. The onus is now on everyone involved in the delivery of healthcare, from the political representatives to the Department of Health and the Health Trusts, from the regulator to the independent sector, to ensure that the recommendations of this report are properly considered and implemented. The goal is a healthcare system which makes patient safety its paramount concern, whatever the question being asked or the issue determined. Patients who have waited for so many years deserve nothing less. Thank you.
Do we bring them here just to do the photograph? Do we just maybe hold the report?
Yeah, okay.
On the notes. Pardon? Yeah, we'll set this out.